Yeah, welcome back. So, taking a look at that court judgment and the others, and then, of course, the perception and impression that people do have of the judiciary. So, we've got Professor Richard Nwokocha, who is an associate professor of public law, Rivers State University, and also former chairman, MBA, Omuku, Rivers State. Good morning, Prof, and thank you for joining us on the program today. Okay, Prof, if you could unmute, I'm not sure, just double check if you're muted yourself, because I didn't hear that response from you. All right, so let me start on a broader note. So if you could just tell us, I mean, you know, do you in any way interface with members of the public about their impression of judgments being handed down by the courts, as it were? And if you do, what impression do you get of them about some of these judgments from courts these days?
So far, the judgments that have been handed down appear to be okay, but you know, from time to time, you have judgments that seem to conflict with others. However, you will need to examine closely the position of the law before you can determine that there is actually a conflict. But definitely, down to the judgment of yesterday, there are issues raised as to what the borderline is between what is a pre-election matter and whether an issue that could be a pre-election matter could also be a live issue or a post-election issue. I think those kind of conflicts will come up, but probably by the time the Supreme Court rules or gives judgment on gubernatorial matters that are going to the Supreme Court that have similar issues, then the situation will become clear from the Supreme Court judgments.
But the ones that ended at the appeal, they won't have the benefits of that. They're gone now, even if you had done by.
They are gone. All matters, since all matters involving the National Assembly end at the Court of Appeal, what it means is that for such matters, they won't have the benefit of being affected by whatever the Supreme Court eventually says concerning those issues. Those are decided because the Court of Appeal decisions are final on those ones.
Do you think that there should be a change? Because there might be some who, at the end of the day, when some of these cases from the governorship gets to the Supreme Court and then they decide, some of them that are gone now in the Assembly may think, you see, same principle applied to ours. Now, look at this. You think that will happen?
Unfortunately, no. Very unlikely that will happen. Again, because election matters are timed. There are timelines, and you cannot revisit a concluded matter. That would definitely be outside the timeline.
No. I'm asking if you think that, for instance, those who their cases ended at the appeal, the National Assembly members, if at the end of the day, the cases are determined by the Supreme Court, the governorship cases, some of them may feel that the cases that are being determined by the Supreme Court may just be the same kind of principle, the similar narrative or similar cases, if I could just use that word, for there. So I'm asking. Yeah.
Definitely, because for many of them, the same issues affecting them are the issues affecting the governorship elections, since the elections are held on the same day. Take the issue of yesterday, for instance, the judgment of Plateau State. If the primaries that produced the governor is faulty because those who were involved in that primaries were not valid delegates, it also means that the same primary that produced those at the national that contested for the National Assembly position was also faulty. So either way, what affects the governorship will affect the National Assembly once it has to do with the root or foundation of the process of election or nomination of those candidates. So definitely there will be that feeling, definitely.
So what, because I mean, the case of Abia, some have said, but the same case that threw out a Labour Party member of the National Assembly did not throw out the governor, because it's the same party, the same principle, the same case, similar matter. But that's on the one hand. Now, about this case of yesterday, which you speak about now, what sticks out for you in that particular case?
Well, the critical The critical issue about that decision is the issue of whether an issue can be both a pre-election matter and a post-election matter. Upon close examination, questioning the process by which a party elected or nominated candidates can be said to be an internal matter, as the courts have heard in a number of those cases you referred to. But perhaps what is peculiar about yesterday's decision is the question it is raising. And that is the question whether the party did at all put up a candidate. Because the law provides for steps that a party has to take if it's interested in contesting in the election. And the argument in that case is that the party did not take those steps and so did not feature in the election. Basically, the law requires that a party that intends to participate should nominate governor by holding primary governorship candidates by holding a primaries, in which delegates will vote in a free and fair environment and express their choice. The argument in this case is that the party did not hold such primaries because what was purportedly held was set aside by a court that ordered that congresses should be held and the entire 17 local governments should be reheld, meaning that whatever they did was set aside by the court, did not exist in the eyes of the law. This is kind of taking us back to 2018 on the issues that emanated from Rivers State. And so once the court nullified them and asked that they be reconducted, non-conducting or non-reconducting of those congresses or what are they called again at the local level, the non-conducting of those exercises now meant that you proceeded to nominate a candidate without complying with the law, that is, doing what the law says you should do if you want to participate in the election, which is holding a primaries, because no valid primary can be held by non-existent persons. Simply means, the argument simply means they had no delegates because the one they were ordered to get was not done. And so whatever they produced was produced without existing delegates. That now has a constitutional flavor and raises the question whether the party exists in the election. And that's what the Court of Appeal resolved or decided, that the party did not participate in the election by virtue of the fact that it did not validly nominate candidates.
So under what circumstances, if you could help us interpret that section 1341 of the Electoral Act, under what circumstances is another party allowed to look into this matter? And then, I mean, the counsel to the PDP there was talking about jurisdiction, that if they speak about sponsorship of a candidate, the question of jurisdiction comes in here. So could you explain that?
Well, if you look at the provision 137, it talks of effect of non-compliance. Yeah, it talks of effect of non-compliance. And it says where the election is nullified by the court and notice of, it shall not be necessary for a party who alleges non-compliance with the provisions of this act for the conduct of election to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. Now, apparently, certified true copies of the judgment of the court ordering the reconduct of the earlier processes must have been tendered before this court. And the question now will be, since the jurisdiction of the election tribunal includes determining whether anybody was validly elected, what the court has done is to determine that that question includes whether a person exists in the first place in the process before he can be validly elected. That's what the decision of yesterday has tried to do. So the argument of the other party is that because it touches on qualification, that it should be a pre-election matter. But the Court of Appeal is saying, if you did not in the first place carry out the processes that the law prescribes for nominating somebody, then you did not nominate and you were not present in the eyes of the law.
Yeah, so Prof, what about the condition preceding that section 137 in 1341, where they talk about the grounds of appeal? Who is it that can? Because some people say that no, but they thought it's supposed to be members of that same political party, not another member of another political party.
Yeah, that's for challenging the outcome of a primaries. But what we are talking about here is whether a primaries was held at all. Yesterday's judgment is saying, in the eyes of the law, no primaries was held because the delegates who should hold the primaries did not exist. The court, High Court, nullified the previous exercise they did electing delegates and ordered them to reconduct those exercises in a manner that is consistent with the law, and that they did not do. They simply went on with the ones elected that the court had set aside to hold the primaries. So the question is, was there a primaries, considering that there were no valid delegates that could have held primaries? And the Court of Appeal is saying that that is a live issue, an issue that can be decided post-election by the election tribunal.
Wow, it's a really delicate situation in Plateau State. And I guess in other states as well. And as you said, a very fine line between determining what will constitute pre-election and post-election matters. But the last time we spoke with you on this program, and I'm going to just rewind a bit, we were speaking with you with regards to the situation in Rivers State. And there's been plenty of quiet there since we last saw that the State Assembly was burnt. You know, there was a bit of fracas between the governor and his predecessor. Can you give us bring us up to speed as to what the current situation is, politically speaking, from what you know on the ground?
Well, there is calm, but a calm that appears to be an uneasy calm, because you have two combatants, and one is consistently saying, we need peace, I'm for peace, and we have to pursue peace. Peace is the best option. The other is not directly saying the opposite, but is consistently talking of conditions and talking of, you touch my structure, XYZ will happen, expect trouble, you're going to have trouble, and all that. So it gives the impression that on one side, it appears to be over, but on the other side, there are still fireworks that are expected. Activities have gone on in Rivers State and in Abuja and all that, that are giving the impression of polarization of the division in the House of Assembly. And remember that the House of Assembly is the theater of the entire crisis. So we cannot say for now that all is calm and that it's all over. The question of who controls the state and whether it is the person determined by the Constitution, or whether it is another person in violation of subsection 2 of section 1 of the Constitution, is still staring us in the face. So we can only hope that somewhere along the line that both parties will come on the same line and will actually have peace. But at the moment, it's a graveyard kind of calm that everybody is anticipating that something will erupt at some stage.
Okay, what about the House of Assembly? You know, we also saw some activities around there. The speaker was purportedly, or no, the leader was purportedly removed. Another speaker was purportedly elected, etc., etc. You know, has there been any confusion as to who the leader is? I mean, or were all of those activities set aside and they went back to status quo? What precisely is the situation?
We can't say for now. The House has not, officially speaking, in the normal environment, has not reconvened, and there appears to still be claims of different speakership. So perhaps until the House is able to reconvene and we find one person presiding, the situation remains that way. I'm not sure the fireworks has taken place, and there has not been a joint sitting of the two factions of the House. So at the moment, we appear to still have speakers both ways, and we appear to still have the House divided between the two factions.
Okay, interesting. So let's look at the matter now, which is before us, the court judgments, and it's very interesting and very delicate, this matter which you raised, because I also know that during the presidential hearings, the presidential election petition hearings, one of the things that was challenged was the membership of former governor and presidential candidate of the Labour Party, his membership of the Labour Party. And the APC was challenging that, saying that he wasn't even a member of the Labour Party at the time that he was contesting to be president. And the Supreme Court seemed to have ruled on that matter. I mean, or not seemed, they did rule on the matter, saying that that was something that somebody within the Labour Party was supposed to have brought up. So, in this particular matter now, you say that this is about contesting whether, Governor Mutfwang was even a candidate at all. And it's not something that somebody within the PDP must bring up. I'm just wondering, how do we tell the difference? How do we tell the difference? When do we say, oh, this is something that is an internal party matter and only somebody within a political party can bring it? And when it is a broader issue that anybody, and I don't know if this is anybody or maybe just another political party or somebody who's contesting an election can raise.
Well, the obvious fact is that we will all have to somehow wait for the Supreme Court to speak finally on it, on what the final position of that issue is. But you recall that even I think that's Kogi State election, the issue of membership of party was also a ground for the Court of Appeal holding the position that it took, which is still subject to final upholding by the Supreme Court when the matter comes up before the Supreme Court. So I think once there is a non-compliance with the constitutional requirements for existing in the process, it may be a ground that may be raised validly by another party. What a party member must raise is any question as to whether the process was properly done. But I think what I'm finding to be the difference is whether process was properly done or was not done at all are two different things. So if the process required by law for you to participate in a process is not followed, that may be a completely different question from whether you followed it and XYZ steps in the process was not fully complied with. That may be an internal matter. But as to whether you presented candidates, I suspect that that may be a matter that may be considered one that can be treated or addressed even after election. But as I said, the Supreme Court will give a final decision on whether or not those separations can be made and whether such pre-election looking matter can survive as a post-election issue. For me, it is non-participation and improper participation. And it appears to me that one that, like this one, that a court nullified the process and you proceeded with it, may lead to the same kind of situation that we had in 2018 in Rivers State, when the Supreme Court said you can't build something on nothing. If there was no process, then you could not have used ghosts or spirits to elect or nominate candidates from a primaries.
Okay, so we'll take a break now. When we come back, I'd like us to take a look at the implications of this, because some people will say, oh, they're not even contesting the votes anymore. This is not a question of, oh, I want more votes here than you did, or, I'm contesting whether or not the people voted for a particular candidate, and what implications this will have for our democracy moving forward. But let's take a break now. We'll be back shortly. Please stay with us. Welcome back. We're still talking about the recent decision of the Court of Appeal sacking the current governor of Plateau State, Caleb Mutfwang. Well, he's since said he's going to be appealing that at the Supreme Court. But in the meantime, we have with us Richard Wokocha, who is an associate professor of public law, Rivers State University, and former chairman of the MBA in Omoko in Rivers State. Prof, so just before we went on break, I did say that we're going to be talking about the implications of this, the fact that, you know, it does appear that the appeal court is quite upset that, well, maybe the word is stronger than upset, but very displeased that a court order looked like it was not obeyed. When the Congress was cancelled and they asked them to go and conduct congresses in all 17 local governments, it does appear that that was not complied with. I mean, we read the words of Justice Okonabang just during the break saying that that was a joke taken too far. And another justice who also said that you cannot, being a member is the first thing first, excuse me, of a political party. But then there are also those who say, look, the PDP was actually put on the ballot and the people stamped their votes in favor of the PDP. That is not being contested. And some people think it's a dangerous precedent for those votes not to matter in the current conversation that we're having. It seems it's a very difficult dilemma that the court has found itself in.
It will appear to be so. But I think we need to look at where this is all going. What really is an issue? There seems to be two questions here. Did the Court of Appeal go beyond what it should go, where it should go? Because the constitutional qualification is that you have to be a member of a party and you have to have been nominated by the party. So there are two things here. Being a member is one ground. Being nominated is a different ground. And the court is saying, if you were not duly nominated, then you were not qualified to contest because that is qualification. And the court is saying that is a live issue that can be raised in a post-election petition. On the other hand, we're arguing whether we should be looking at whether the party itself not conforming with the law is an issue that we should worry about. Because elections are process-driven and internal democracy is always key in talking about the final value of the process. So if the law provides what should be done and a court orders you, remember, it's not just the issue of a court ordering. It's about the implication of a court nullifying a process and ordering its reconduct. In law, when a court nullifies a process, that process is as good as not having been held. And so if the court orders that you should reconduct, not reconducting it means that you did not at all conduct the process, which is a necessity.
Well, sincere apologies about that, Prof. But, you know, one of the things that struck me very strongly when you began to talk about the thing, you know, either held or not held properly. One issue that's been recurring in my mind, that in the entire process, no one has mentioned INEC. I believe that, I mean, unless, you know, the facts have changed, INEC is supposed to monitor all primaries of political party. Now, when we hear cases such as you have, you know, detailed to us that the court nullified a primary process, and then INEC eventually put the name of that particular candidate on the ballot. First of all, let's answer the question whether or not you think INEC could have been indicted in this, given that they were supposed to monitor a validly held primaries.
Very possible. It's very possible that you could have joined INEC, or you could have blamed INEC. But I think they were probably trying to be smart, because if you do that, that may bring it more in line with the pre-election question. Because any question as to whether INEC validly or improperly stopped a candidate is one that is to be determined as a pre-election question. So they may have smartly, if you like, chosen to avoid that route so that it doesn't emphasize that issue of pre-election question, and they are focusing on the issue of qualification according to the Constitution, valid nomination.
Yeah, but then who should confirm whether someone was validly nominated or not? The process ought to have been through a primary. I listened to Mr. Chiabaisi and also saying there that the court used the language sponsorship, not nomination. Now, the fact that the name of the individual was on the ballot in the first place is something that I'm wondering, why would that happen if we have an umpire who is supposed to ensure that only the properly nominated individuals got on the ballot in the first place? And the process of nomination includes being a candidate being sponsored by a political party whose image is the one on the ballot and not the image of the candidate.
You know, the facts of this case, I can't tell if that's what deceived INEC, but the court ordered reconduct in the entire 17 local governments, and they had a reconduct in 5 local governments. Did that deceive INEC into thinking that they had complied with the law? That is one issue. But does the position of INEC, whether it accepts or does not accept, override the constitutional provision of valid nomination, which is sponsorship? That's the language of the Constitution. Does it override the constitutional provision for sponsorship by a political party? I'm afraid that even if INEC was in error, it will not amount to an amendment of the law. It does not change the position of the law.
Well, you know, Prof, it's very interesting, I mean, where this is all going. Well, Marquez stated this issue of the voter the other time. All of the votes that went, and it also underscores what Mr. Falana SAN also said in the slide we presented earlier. Why should the voter be the one to be punished for the errors of a political party? Do you see an end to this kind of process where after the voters have cast their votes, selected, and the process has produced someone, then the court is the one that acts like some kind of electoral college to determine whether or not the person that the people elected was supposed to be in office in the first place? How do you see all of that playing out, particularly for the voter whose confidence in the electoral process is already shaky?
I agree completely that these developments affect voters' confidence on one hand, and secondly, where INEC is in default, that they should be punished, but that is already the position of the law. So if we are not doing it, it's not a question of lack of provision of the law, it's a question of our not implementing what is in the law. The law provides that if anybody, including any electoral official, engages in any activity that compromises the election, that he should be brought to book. There are provisions to that effect. So I think that is different. But I am afraid that not obeying a court order is not one for which you can hold INEC responsible. It's a misconduct on your own part, and a misconduct for which you will pay the price should it arise. So in this case, opponents have taken up the non-compliance with the order of the court and pointed out to the tribunal that, look, this means they did not have any exercise at all. They did not join in this election because they did not do what the law says should be done to come into the election. It's not a question of whether they did it properly or not properly, like an aspirant should contest. This is non-sponsorship, and the court has agreed with them. So I think it's not really INEC in this particular case that we should be worried about. It is the parties not complying with the provisions of the law.
I understand.
Especially where they are.
Yes, go ahead, sir.
Yes. Yeah, especially where that attention has been drawn to it by a court that has invalidated what was done.
Okay.
Well, if you were in error and you did not realize you were in error, and a court calls your attention to it by giving you a judicial decision and you fail to comply with it, I am afraid we cannot blame any other person. It's entirely your action, and you will be entirely responsible for it.
The other wing of that question, Prof, is the result of the elections and the confidence of the voter. As far as they are concerned, whoever is on the ballot, whose name appears, whose image or whatever appears on the ballot, has gone through the process. So when they vote for these particular individuals and the results are counted and this fellow is said to have won, both in the case, for Plateau and Kano as well. And they said that, okay, this fellow has won the election. In the case of Kano, they're saying that there was no membership. He was not a member of the political party in the first place. So for as long as the voter can see the name of this individual on the ballot, their assumption is that the fellow has gone through the process. And it only indicts the electoral umpire if it is the court that now says that this individual didn't go through the process properly in the first place. So how do we ensure that whoever is going to get on the ballot in the first place, I'm not even talking about this nomination thing, I'm talking about the sponsorship, the process, because the voter is now, we saw jubilation, we saw protests in different parts of both of these states, for and against. The voter is right now the one who is at the lower rung of the ladder, who is bearing the bitter end of the stick. So how do we ensure that? What are we missing to ensure that whoever gets on the ballot in the first place is the person that should be on the ballot and the people's vote will count? Because with these judgments now, it seems that the people's vote is not counting.
I think that's the question we need to examine closely. Now, if you look at the present position of the law, does INEC really have powers to disqualify a person? I know that that has been implied in some decision, but look at the provision of the law establishing INEC. Ask yourself whether the law gives INEC the power to do so. Remember again that the Electoral Act says anybody who has any question to that effect should approach the courts. Can INEC play the role of or part of the court? If INEC is not the court and INEC cannot determine the legitimacy of participation, can we really hold INEC responsible if at the end of the day the court finds that in interpreting a situation that a particular party or a particular candidate was not validly brought into the process, was not validly sponsored or nominated by his party? It appears to be a matter that is outside INEC, because INEC has not even been given the powers to play the role of the court in such matter. The provision in the Electoral Act asking for a person who feels otherwise to go to court for a judicial determination of that fact is still there in the law. So can INEC assume the powers of the courts?
Okay.
I suspect the answer will be no.
Interesting. So now both parties in Plateau State and in Kano State have decided that they're going to the Supreme Court. Do you see anything changing given the facts that you have reeled out? Because you also said that perhaps there is a necessity for the Supreme Court to give some clarification on some of these things. What are your expectations?
Well, we have, in those two matters, we have one issue raised, and that is whether we can have an issue of qualification arising after election for determination by the election tribunal. And I think that is what the Supreme Court is going to shed light on, because the question of party membership and valid nomination, otherwise called sponsorship by a political party, which is contained in the Constitution, are the issues that are in question, and they are all issues of whether the candidate was qualified to be elected. And if you go by the Electoral Act, grants of petition, you may actually find that the electoral petition tribunal or court tribunal may have some competence to answer some of these questions.
So Prof, pardon me if I could just jump in. I see different lawyers also raising key issues. They say, but there's already precedents from the Court of Appeal and Supreme Court on the same subject matter. So does that then mean that they're jettisoning precedents in this kind of case? But besides that, just one more before we go. The members of the party, the PDP, say, look, this is not about conducting primaries for officers in those political offices. that it is about Congress, party Congress in 2021, and that they had it in 17 local government areas. They had quorum and not primaries, as many seem to say. And that they even show documents that that was done.
Yes, in 5 local governments, unless there is another certificate of fact that was not produced before the petition tribunal. The other was reconduct the 11. They reconducted 5 and used delegates from the remaining number, which is 6. Used delegates from all of them to conduct primaries. It raises question of who nominated or who elected the aspirants that became candidates at the primaries, who held the primaries. So if you partially complied with the decision of the court and left some, you have questions to answer. Now, on the first issue of precedent by a court of appeal, the court of appeal is a court of appeal. And if the court of appeal holds 2 different opinions, that's why we'll have the Supreme Court that will eventually decide it. The decision of a court of appeal has persuasive effect on another court of appeal, that is another sitting of the court of appeal. It does not have the binding effect that decision of a superior court, the Supreme Court, will have on such courts. So at the end of the day, it is the superior court, which is the Supreme Court, that will determine which of the positions taken by the 2 court of appeal decisions is consistent with the law. And that's why we have the appellate system up to the Supreme Court in those matters.
All right, then Richard Nwokocha, Associate Professor of Public Law, Rivers State University, and former Chairman, MBA Omuku. Thank you for joining us this morning.
So citizens' duty. Thanks for having me.
All right, well, back in a moment. We'll focus in on Kano next. Stay on with us.